If you are injured at work, you may be entitled to compensation under the Mississippi Workers' Compensation Act. This video provides some basic information on the Act and how to pursue a claim.
Knock it off. Sorry. Cassandra?
Ted,
Did you come for files today?
I did.
Are you leaving?
Bye, Ted.
Already?
Ted, you okay?
Yeah.
Are you okay?
Yeah.
Okay.
My supervisor told me to come talk to you.
Bill called me and said you hurt yourself on the job?
Yeah, I was lifting some parts to fill an order and I pulled something.
When did this happen?
About 3.5 weeks ago.
Have you seen a doctor?
Yeah, I went to see my doctor. He sent me to a back specialist and he thinks I probably need surgery. It's kind of a huge bummer.
Have you received any medical treatment?
Depends what you need by treatment. They've done some x-rays, given me some medicine, sent me out for exercises, and I had an MRI. Look, I've never been hurt before. And you should know I was actually scared to tell my supervisor, but Bill was cool with it. He just told me I had to go to Human Resources.
No, you did the right thing. In Mississippi, all work-related injuries should be reported to the employer.
So I've heard of workers' compensation, but I really don't know much about it.
Let's start with the big picture. You are qualified to receive benefits under the workers' compensation laws. Your employer will pay your medical bills and replace some of your lost wages.
How's that?
The whole purpose of the workers' compensation law is to get you back to work quickly. The idea is to restore you to health and give you some partial wage replacement.
Do all employers provide workers' compensation benefits?
Now, in Mississippi, any employer with 5 or more regularly employed workers, like our company, have to have workers' compensation coverage. But employers with fewer than 5 employees may choose to have or not have the coverage. In other words, they can get it if they want.
I don't want to sue anyone, but I've been told in Mississippi, workers' compensation is my only option and that I can't sue anyone.
That's true. Unlike laws that govern other types of injuries, workers' compensation laws cover work injuries on the job, and you cannot file a regular lawsuit for workers' compensation benefits.
I'm not sure I understand.
It's work connection and not fault that determines whether an injury is compensable under the Act.
Does that mean that it happened at work?
Essentially, that's right. Work connection means the injury happened on the job or because of your job.
Does that mean that I can't sue my job over my injuries?
Yes. In general, your work injury benefit will be limited to those provided by the Workers' Compensation Act. Regardless of fault, the employer must pay benefits for injuries in exchange for this no-fault coverage. The employee is typically limited to recovery under the Act, even when the injury may have been caused by the employer.
Are workers' compensation benefits unlimited?
No, they aren't. Workers' compensation benefits are limited in scope and amount. The amount that an employee may receive in disability benefits or lost wage benefits per week is limited, as are benefits over the life of a claim. Also, the amount and number of weeks of benefits are limited.
What about doctor bills?
Medical benefits are different. They don't have the same limitations, but benefits are not paid for certain kinds of losses that are compensable in a court of law.
For example?
For example, the employer is not required to compensate an employee for pain and suffering that may result from a work injury. Obviously, this is different from personal injury or car accident types of cases.
If I wasn't a citizen of the United States, could I still bring a claim?
Absolutely. In Mississippi, U.S. citizenship is not a requirement to receive benefits for a work injury.
Hey, Teddy. Miss Jackson, I didn't mean to interrupt. I just wanted to know when you would be available to talk about my workers' compensation claim. My doctor says that I have carpal tunnel syndrome.
Well, if Teddy doesn't object, why don't we move to a conference room and I can explain the Workers' Compensation Act to you both without getting into the specifics of your claims.
It's okay by me.
Me too.
All right, there's some paper there if you want to take notes. Why don't we start off with any questions you might have?
I didn't report a claim on the day that I was injured. Does that mean that I don't get benefits? I mean, is there a time limit by which I have to report a work injury?
Well, the Act requires that notice of an injury be given to the employer within 30 days after the injury. Your benefits, however, will not be denied based solely on a lack of timely notice unless it's found that failure to tell the employer about the injury within 30 days harmed the employer's ability to defend the claim.
What do you mean?
An example would be if you had gotten back surgery before you ever told your employer you were hurt.
I didn't report that I was hurt immediately. Does that mean I can't report it now?
Many employers require you to report your injury within a specified time frame and have consequences regarding your employment if you don't do that. But regardless of your employer's requirements, you may still file a claim for benefits under Mississippi workers' compensation laws.
Well, do employers have to report claims? Because after I told my supervisor about the carpal tunnel, I still don't think he's reported it.
Have you missed any work?
No.
Because generally speaking, employers have 10 days to report injuries resulting in lost time of more than 5 days.
Do I need an attorney or can I file the claim myself?
You file what we call a petition to controvert. The petition is filed with the Mississippi Workers' Compensation Commission.
Great. Do you have 3 copies here?
I do.
All right, let me stamp those in. And that's your copy.
All right, thank you.
Thank you.
You can find the forms at the Mississippi Workers' Compensation Commission at 1428 Lakeland Drive, Jackson, Mississippi, 39216. And you can find them on the Commission's website as well, www.mwcc.ms.gov.
How long do I have to file a workers' compensation claim?
In general, if no benefits have been paid other than medical or burial expenses, you have 2 years from the date of injury to file a petition to controvert with the Commission. But if disability benefits have been paid, there is a 1-year period which begins to run with the filing of what's called Form B-31. Statute of limitations questions can be a little bit tricky, and there are exceptions to these general rules. You should consult the Commission or an attorney with questions.
Who's going to decide if I get benefits?
Well, the Mississippi Workers' Compensation Commission is the state agency that first determines your right to receive benefits if they're challenged by the employers. You would have an administrative law judge assigned to your claim if there was a dispute. However, about 85% of work injury claims in Mississippi are paid voluntarily. If there is a dispute in the case, for example, a dispute as to whether an accident happened at work or how disabling an injury is, then an administrative judge will conduct a hearing, receive evidence offered by you and the employer, and enter a written order deciding the issues.
If I don't like the administrative judge's order, can I appeal?
You or the employer can appeal the administrative judge's order to the 3 agency heads of the commission. They'll enter another order, and the commission's order can be appealed further to the Mississippi Supreme Court.
Can I choose my own doctor?
You have the right to either pick your doctor or accept the doctor offered by the employer. Just remember that if you're treated by a doctor for more than 6 months or have surgery due to a work injury, that doctor will generally be considered your choice of medical provider, even if your employer selected the doctor.
I don't have a lot of bills right now, but if I get the surgery my doctor suggests, what kind of benefits can I expect from a workers' compensation claim?
I can't speak to your claim specifically, but I can tell you what the Act says. There are 2 different kinds of workers' compensation: medical benefits and lost wage benefits.
What's the difference between the benefits?
Medical benefits and lost wage benefits. Now, medical benefits are payments for medical care related to your injury that the employer pays, usually through an insurance company or a self-insured administrator. These payments go directly to the doctors, hospitals, and other medical providers. Lost wage benefits compensate you, at least in part, for wages lost while you're off work because of the injury. If you are left with any type of permanent disability from your work injury, you might be entitled to additional lost wage or disability benefits as well. Disability benefits are paid directly to you, the employee.
Are medical benefits paid directly from the date of my injury?
Yes, they are. An employee is entitled to medical benefits from the date of injury. However, for that to happen, the injury must be work-connected. If an injury is work-connected, you are not responsible for co-payments. Also, doctors and hospitals and other healthcare providers cannot collect from you for any part of the bill that remains after the employer has paid what the Act says is owed.
What type of medical benefits can I anticipate receiving?
Medical benefits are not limited by type or amount so long as the treatment is related to the work injury as well as reasonable and necessary. In other words, the employer will provide medical benefits for as long as they're needed to return the worker to health and vocational opportunity, even if that means the worker will receive medical benefits for the rest of his or her life.
What's vocational opportunity?
Vocational opportunity means you are physically able to do the job you were working before you were injured, or you are physically able to return to some other gainful employment.
So are there any other limits to medical benefits?
Like I said, medical benefits are not limited in amount as long as they're related to the work injury and are reasonable and necessary. But it's important to know that after the healing process is complete, the employer may file a form called a B-31 with the Commission. If the employer files a Form B-31 and you do not receive medical treatment within 1 year, you may lose your right to medical benefits.
So how long do I have to be off work before I can start receiving benefits?
It depends on what benefit you're talking about. Medical benefits begin immediately after the work injury. Usually when employees ask how long it will be before they start receiving benefits, they're trying to determine when they'll receive their first benefit check.
Exactly.
Right.
It can be complicated, but the short answer for that question is that the first check for indemnity benefits is usually provided about 2 weeks after a disabling injury, if the disability lasts 5 or more days.
How much will I receive in benefits?
This is one of the most common questions workers have when they realize their injury is going to require them to miss work and a paycheck. The amount of benefits paid is dependent on how much you were earning on average in gross wages at the time of your injury.
Okay, I need to take a few notes on this. What do you mean?
Generally, the benefit rate is 2/3 of the average wages you earned per week before the injury. That said, there is a maximum amount that can be paid per week, regardless of how much you were making. That amount goes up each year, and you can find the maximum amount for the year of injury on the Commission website.
Are workers' compensation disability benefits paid for pain and suffering?
No, disability benefits are only based on anatomic loss or wage loss.
Does the employer have to keep paying my health insurance and other premiums while I'm off work?
There's nothing in the Mississippi Workers' Compensation Act that requires an employer to continue making premium payments on behalf of an injured worker. Some employers choose to continue paying premiums and others don't. And you or your representative should contact the employer directly through the Human Resources or Personnel Department. You should ask the employer's policy about paying premiums on health insurance and other benefit plans.
Can my employer make me use my vacation or sick leave time when I'm off work due to a work injury?
The Mississippi Workers' Compensation Act does not have a law or rule preventing employers from crediting dates missed due to injury against vacation or other benefits that were built up before the injury. But every employment situation is different. Some employees may have protections through collective bargaining agreements, employee handbooks, or employment contracts to prevent leave time from being exhausted if an employee is injured and unable to work.
So, Ms. Jackson, how much can an attorney charge in fees, and are the fees taken from my benefits check?
The Mississippi Workers' Compensation Act allows an attorney's fee of up to 25% of disability benefits paid or awarded. The Commission has the authority to monitor attorney fees, and you can always check with the Commission to make sure the fees are within state law.
Can my employer fire me if I'm out of work due to a work injury?
This is a difficult question because everyone's employment situation is different. From the standpoint of the Mississippi Workers' Compensation Law, there is no statute or rule that prevents an employer from terminating a worker who's unable to work due to an on-the-job injury. Some employees may have job protection through collective bargaining agreements, employee handbooks, or under federal anti-discrimination laws. But as of now, Mississippi does not have a workers' compensation law that provides job protection for disabled workers. If you have questions, you should review the information on the website for the Mississippi Workers' Compensation Commission or consult with an attorney.